In this video, we'll be concerned with the Data Protection Act as applies in the UK. The Data Protection Act 1998 holds significant value for organisations and customers. It is an extremely important act for any business that uses computer technology to hold and store data. So it's a very important act that businesses must take into account. The Act has been introduced to give customers more control over the use of their personal data. With the increasing use of the Internet and e-commerce, there's a greater need for control and consumer protection. We deal with businesses through computer technology more and more, and the capacity of businesses to store personal information has become increasingly easy for businesses to do. And to that end, it's important that the businesses have responsibility for the data and ensure its security. The Act is in place to protect the privacy and integrity of customer data held by an organisation. So it's important that organisations hold personal data securely and don't release it or sell it on or abuse the data in the sense that the owner of the data, the person to whom the data applies, is not adversely affected. So the Data Protection Act is really a product of the computer age. The need for data protection has probably always been around, but it's come to the fore with the advent of sophisticated databases and sophisticated communications technologies and integration of computer systems. A business may collect and store customer details when a transaction takes place. Information may be the name of the person, the address, the contact details, the payment information, employment details, purchase history and transactions. So there's a lot of data that's collected at the point of sale. And that data will be entered onto a database and may be used to contact the person for future sales and promotions if an email address, for example, was collected, or a home address. Now, that is at one level, but there is a second level that sometimes databases are linked between companies or between organizations, between suppliers and retailers and so on, and the information that the customer gave at the point of sale may be used by organizations who were not directly involved in the first transaction. So for this reason alone, the Data Protection Act is very important. Under the Act, customers have the right to request and view their details held by an organisation. They may also request up-to-date details if necessary. Customer data is classified as sensitive and may result in fraudulent activity if it falls into the hands of the wrong person. So it's important that people who give their details, perhaps innocently give their details to a retailer at the point of sale, at the point of purchase of a product, they don't expect that detail or those details to be used fraudulently by other organizations or by organizations who have access to the database. And there have been cases where companies have collected data and sold the data, actually sold the data to other organizations for marketing purposes. Now, that was not the intention of the purchaser when he or she handed over his or her details at the point of sale, at the point where they purchased the product. Perhaps they gave their name, their address, their email address and so on, innocently, thinking that company alone would have it, not expecting that it would be sold on to other companies, and they would start to receive promotional material from other companies and be targeted by other companies. Information must be processed fairly and in a lawful manner. That's really the essence of the Act. The information must be processed fairly and in a lawful manner. The customer must be aware and give consent for the storing of personal data. The customer must be aware and must give consent for the storing of personal data. So they just can't take the details and enter them on the database. The customer must permit this to happen. And the customer must be fully aware of the information that's collected. What information has been handed over? Name, address, email address, telephone number. What is it exactly that's going on record? Now, the consent can be verbal or it could be a signed contract. That may be a weakness, that it's verbal. Perhaps it should be a signed document that signifies that the customer gives consent for the data to be stored. The information that's processed should be held for limited purposes. It should in fact be held for some specific purpose. If we purchase a customer product, let's say we purchase a television, and we hand over our details, our telephone number, email address, our payment method. We hand over a lot of information at the point of purchase. The reason why we're doing that is in case there is something wrong with the television, in case we have a problem, in case we need to rely on the warranties or on contacting the organization, or we don't expect that information to be used for some other purpose. Information can only be held and processed under the guidance of the ICO, the Information Commissioner's Office, the ICO. So it's the ICO, the Information Commissioner's Office, that has overall responsibility for the data that's collected. Data must not be used in any other manner than agreed with the customer and the ICO. So the information is only collected for some particular purpose, and it should only be used for that purpose. Individuals must consent for their data to be processed other than previously agreed. So if subsequently the organization contacts the person who has given their personal details, contacts them and asks if it is acceptable that they use the information for some other purpose, and if then the person agrees, then that's okay, that's valid. But it should be with their consent. In other words, we own our information. I own my name, I own my telephone number, my email address, and I only share these if I want to. And it is not right for someone to take my information and pass it to a third party without my consent. Data must be adequate and sufficient for its purpose. Data collected and stored must be necessary for the business activity. So in fairness to organizations, if they do need to contact us, we should, in fairness, enable them to do so by giving them accurate information. But organizations must not hold personal data which is not their concern and has no relevance to business activity. So the items I purchase from other retailers is not the business of perhaps a particular retailer, if I'm buying a television, they shouldn't know it shouldn't be relevant to them what sort of car I drive. That's nothing to do with the television. So why are they asking me about the car? Why are they asking me where I do my grocery shopping? So information should be specific to the product that I'm purchasing or to the transaction I'm undertaking. The organization will be liable and will be in breach of the Data Protection Act if they retain irrelevant information. So organizations must only have information which is relevant. Data must be accurate and up to date. The organization must ensure data is current and up to date. Data must be immediately updated if incorrect. It's wrong for organizations to store data which is not accurate. It gives a false impression of the person that relates to the data. It may be that the accusation could be that the person gave false data, which is not true. Perhaps it was just wrongly recorded. So it's important that the data is up to date and it is accurate. So inaccurate information could result in misunderstanding and misrepresentation, and that's a problem. Data must not be stored for longer than required. Customer details must not be stored for longer than needed. So back to the television example, perhaps the warranty on the television is 3 years. So perhaps they need to hold the data for 3 years. But after that period, the data should be deleted. They have no right to the data. They have no right to hold my personal details after that period, because the data was collected for a purpose, and the purpose has now expired. If a customer makes no sales or purchases after a certain time period, the record must be safely discarded. Safely discarded means deleted, erased. It should not be printed off and thrown into a bin where someone else can retrieve it and go on to use it. The data controller must review records on a regular basis and contact customers to ensure they are still interesting and making purchases. They are still interested, I suppose, is the proper word. Interested in products and making purchases. So data controllers should ensure that the customers are active. If they're not making purchases, and if the relevant period which was agreed when the data was originally handed over, if that's about to lapse, then the data should be deleted. It's no longer relevant. Individual rights must be considered before data can be processed. So individual rights must be considered before data can be processed. Customers have rights to access their data. So customers should be able to access the data and see what's stored on file about them. Object to the processing of their data. If their data is processed, then they should object to it, or they may object to it. So if their data is being manipulated in some way, then that is something that they may object to. They may object to direct marketing. They may refuse to participate in direct marketing. Simply because they made a purchase at one time period and handed over details about themselves doesn't mean that that data can now be used to contact them perhaps in the future to make sales of related products or other products. That's not fair. They didn't ask for that. They didn't require that. and that was not their intention when they first handed over their details. So it's not right that the data should be used for direct marketing at a later date. But customers have a right to change, amend, and block their data. So they can change and amend and block their data if they wish to do so. They also should have the right to compensation for breach of the Act. If a company misuses their data, then the person who suffers as a consequence should have a right to compensation. The information must be kept secure. The data controller must ensure that the data is kept secure, either on a computer system or manual file keeping. But whichever method is used, it should be secure. And the person responsible for holding the data should make every effort to ensure its security. Information can be lost or in the hands of unauthorized users. This is a breach of the Act due to negligence. So if the information is leaked out of the system to third parties who start to use the information, that's negligence on the person who is charged with the security of the data. The organization was negligent. They allowed the data to be accessed by a third party and used by a third party. So they were negligent in allowing this to happen. Information must not be transferred outside the European Union. Data relating to a third party must not be stored overseas without the individual's consent. It's important that the individual agrees to where the data is stored. And if it's outside the European Union, in other words, outside of the legal framework of the European Union, then the person to whom the data applies should give consent for that, explicit consent. And the individual has the right to have their data withdrawn at any time. So as we can see, the Data Protection Act is quite comprehensive. It seems to cover many areas associated with the storage of data relating to individuals. It gives the individuals the right over their own data. They allow companies to store their data for commercial reasons related to that particular, let's say, purchase or that particular transaction in the case of a bank. But the organizations storing the data have an obligation, first of all, for the security of the data, and secondly, they must not allow third parties to access the data or indeed sell on the data to third parties or make it available to third parties for any purpose, including direct marketing. So it's an important act. It's one we should be familiar with. It applies in many countries, in fact. It may be modified to some extent in some areas, but many countries have now got similar legislation in place. And with the advent of very sophisticated algorithms on computers and search bots and so on, there is more of a need to ensure that the individual is protected. And this type of legislation is starting to crop up in many areas, many countries. That's all I'm going to deal with in this class. So that's the Data Protection Act, and thank you for watching.